I'm reading Criminal Law, Chapter 9, Responsibility Modifying Circumstances. This is Section 2, titled Impelled Perpetration. A command or order not backed up by public authority will not excuse a deed which would otherwise be a crime. This is on page 880. Under certain circumstances, one who has carried out a private command or order may be free from guilt altogether. The criminal law was violated. Maybe I should try that again. I'm on page 880, and the second sentence under impelled perpetration. Under certain circumstances, one who has carried out a private command or order may be free from guilt, although the criminal law was violated, but the excuse will be based upon some other ground, such as lack of a necessary mental element for criminal culpability. If, for example, the thing commanded is not obviously wrongful and the order is carried out in innocence of a criminal purpose intended, the innocent agent is not guilty of a crime. This may happen in various ways, such as where an employer commits larceny by directing an employee to take a certain chattel, which actually belongs to another, and place it in the employer's house or store. The employee is not guilty of crime if he carries out this order in the innocent belief that the chattel belongs to his employer. In such cases, however, it is the mistake of fact and not the command which constitutes the excuse. If a command or order is accompanied by violence or threat of violence, a real problem is not the command but the compulsion. An act is a willed movement. Hence, if one's body is propelled against his will, this is not his act. The classic example is this. A, B, and C are standing near the edge of a precipice. Suddenly, A shoves B violently against C, causing C to fall to his death. A has caused the death of C, but B, whose body was used as a tool by A, so to speak, has not caused this death. B did not act, he was acted upon. Such a situation is mentioned to avoid any possible misunderstanding, but compulsion has quite a different meaning. Compulsion, as used in this connection, applies where it is the will rather than the body which is coerced. If in a case similar to the one mentioned, A had not touched B but had pointed a loaded pistol at B and threatened to kill B unless B pushed C over the edge, and B had done this to save B's own life, it would have been a case of compulsion. In this case, B had a choice. It was not an easy choice, to be sure, but when B decided to push C, causing C's death rather than B's own life, this was a willed movement and hence an act. And the resulting death is legally imputable to B as well as A. Whether B is criminally responsible for the death B has caused depends upon whether or not this compulsion will be recognized as an excuse. Statements can be found by some of the early writers indicating that no person is ever criminally answerable for what the person was compelled to do in order to save his own life. And unquestionably such compulsion or necessity would be recognized as an excuse for most deeds which would otherwise be criminal. But Blackstone asserted, though a man be violently assaulted and hath no other possible means of escaping death but by killing an innocent person, this fear and force shall not acquit him of murder, for he thought rather to die himself than escape by the murder of innocent. No sound analogy can be drawn from the self-defense cases because that defense does not involve the killing of an innocent person. And the very few cases of this nature which have reached the courtroom show that the common law does not justify or excuse such a killing. Strangely enough, the possibility of manslaughter rather than murder in such cases seems not to have been adopted as another approach. The killing is intentional, to be sure, and there is no legally recognized provocation. But the circumstances are extremely mitigating. The mitigation is such, in such a case, is entitled to greater recognition than that in most instances of voluntary manslaughter committed in the heat of passion. The state of mind of one who reluctantly takes the life of an innocent person as the only means of saving his own, while not guiltless, is certainly not malice aforethought. The statement above refers to the common law. In some of the new penal codes, it is provided that such a killing is manslaughter. In other codes following the Model Penal Code, Section 2.09, the defense of duress is available in homicide cases. For most offenses, however, a well-grounded fear of imminent death or great bodily injury is recognized as an excuse. One is not punishable for robbery because of having driven the getaway car for robbers if it is done at the point of a pistol and under the threat of immediate death. And one who damaged a threshing machine with a sledgehammer was held not guilty of crime when it was found that he had been compelled to do so by a violent mob. It was even recognized that one who joins the enemy forces in time of war is not guilty of treason if he does so in fear of death or great bodily injury, and escapes at the first reasonable opportunity, provided he has not caused death in the meantime. It has been argued that if such compulsion will excuse treason, it should excuse any crime, and therefore murder. The answer, however, is obvious. Joining enemy forces with mental reservation and leaving at the earliest opportunity causes no lasting harm. Homicide does. So, what we're saying is that it's excuses, all crimes besides murder, besides homicide. The word compulsion, as it is used in the criminal law, is limited usually to situations in which the unwilling action is compelled by some other person. Quite similar emergencies may arise in which the pressure is exerted by some other agency, and the result is the same. Here also it is necessary to distinguish between forcing the body and forcing the will. Treating physical impossibility and extreme pressure in circumstances as if they were identical is one of the oldest fallacies of the law. If a tornado hurls the body of A against B with fatal results to B, this death is not caused by an act of A, but if A and B are adrift in a small boat 1,000 miles from land and without food, and A kills B and eats his flesh as the only means of saving his own life, this death is caused by A. Traditionally, no matter how great the necessity, the law will not excuse the intentional killing of an innocent person on the plea that it was necessary to save the life of the slayer. In the boat case mentioned, the English court insisted that the crime was murder and pronounced sentence of death, but the sentence was afterward commuted by the Crown to 6 months imprisonment. It would seem that circumstances so obviously and extremely mitigating as to cause such a reduction by the pardoning power should have been recognized by the court as reducing the grade of the crime itself. In the famous case of human jettison, the actual verdict was guilty of manslaughter. In this case, a leaking boat loaded with survivors after a shipwreck was in grave danger of sinking in a storm. It was not a modern lifeboat, and all would have been lost if it had gone down. The sailors threw some passengers overboard to lighten the load. As thus lightened, the boat was kept afloat during the storm, and the survivors were picked up by a passing vessel the following day. The judge charged the jury that the sailors had no privilege to sacrifice passengers, even if such extreme peril. He intimated, although it was quite beside the point, that if several are in such peril that some must be sacrificed in order to do for any to be saved, and none of the group owes any duty to others. In this emergency, choice by lot would be proper. What seems to be the traditionally accepted view among the few cases is that no one is privileged to choose the death of some other innocent person in order to preserve one's own life. In extreme emergencies, however, the field of legally recognized causation may be somewhat narrow. One may not willfully plunge a knife into an obviously guiltless breast, but it does not follow that in a race or even a struggle for means of safety adequate to preserve the life of only one, the winner shall, under all circumstances, be said to have killed the loser. On the other hand, where the necessity is great, indeed not involving death or great bodily harm, may be excused even if otherwise it would be a crime. For example, if merchant vessels are forbidden to enter a certain port, and such a ship is forced to take refuge there during a violent storm for the safety of the vessel and those on board, there has been no violation of the embargo. What might otherwise constitute attempted revolt by sailors on the high seas may be excused by the unseaworthiness of the vessel. Where a prisoner is confined in immediate life-threatening circumstances, the person may be privileged to escape from the situation until the threat has subsided. However, general bad prison conditions will not provide a defense to the charge of escape. The problem that seems to have aroused the most discussion and the least litigation is that of taking food to avoid starvation. Although Lord Bacon has said if a man steals viands to satisfy a present hunger, this is no felony or larceny. Because it's a motive and not intent. Hunger is a motive. And anyway, the books are full of statements indicating that economic necessity is no defense to a criminal charge. And it has been so held. But economic necessity, as the phrase has been used, falls far short of actual needs to prevent starvation. And mere convenience will not excuse the intentional deprivation of another's property. Under ordinary circumstances in the modern community, it is not necessary to take another's food without his consent because an appeal may be made to the public authorities. But if a ship should be disabled on the high seas and its communications destroyed, and those on board, after exhausting the ship's provisions, should find that part of the cargo was food and should break open boxes of freight and eat the contents as the only means of saving themselves from starvation, they would not be guilty of larceny. Doubtless the lack of any case holding such an appropriation not to be larceny or contra is because the result is too obvious to have resulted in prosecution. The necessity is determined by an objective standard. The bank cashier who hands over money to an armed bandit under threat of immediate death if the cashier refuses, thereby appropriates the bank's money to save the cashier's own life. But this is not theft. More like it is not embezzlement. The Model Penal Code and statutes of some states have adopted a standard for duress that is more liberal than the traditional rule. The standard recognizes a defense to any crime if the actor was coerced to commit the offense by use or threat to use unlawful force against him or another, which a person of reasonable firmness in his situation would have been unable to resist. The Model Penal Code also recognizes that conduct may be justifiable if the actor believes it to be necessary to avoid a harm or evil to himself or another, or the harm or evil to be avoided is greater than the conduct sought to be prevented. This embodies a choice of evils for the actor and a defense so long as the actor has not made an inappropriate choice. The concept of choice of evils does not necessarily rule out the alternative defense of duress. Some courts have recognized the availability of a defense of choice of evils or necessity in proper circumstances, but a real emergency must be shown, not merely a choice of courses of action before the defense is available.